Good morning.
Out of curiosity, you know, when we talk about driving under the influence of marijuana, it's quite a bit different in terms of being able to prove it, or for law enforcement to be able to prove it, compared to, for instance, driving under the influence of alcohol. Maybe if they're firing up in the vehicle, you can smell the pot inside, but if they smoked the pot before they got in the vehicle, or they're eating gummies, edibles, whatever, you're not even going to be able to smell that. What is kind of the legal test that officers try to perform to show that a person is driving high?
It's really tough, and it takes a lot of training. So a lot of the National Highway Safety Transportation, all of their training is geared towards field sobriety tests that correlate to breath alcohol above a 0.08. Mm-hmm. The tests don't necessarily correlate to cannabis or other drugs. Law enforcement tries to train people for that specific discipline, but it's really hard. England, back whenever, they had to have a doctor certify you as intoxicated. I don't know that it quite takes that, but it's very difficult, and really, practically speaking, you have to have a blood test of some sort to really get in there. But you got to legally build that case up in order to have the probable cause, the reasonable suspicion, a warrant, if you will, in some instances, to get the blood. Very hard to prove.
Okay, and even if you do get the blood test or a blood is drawn, my understanding is that THC, the active ingredient, lingers in the blood for a considerable length of time, and that, it's even difficult to prove from that. Am I correct on that, or has technology changed?
So I need to stay in my lane. I'm a lawyer, not a toxicologist. But I'll tell you this: in the cases that I've seen, they can distinguish a metabolite, something that has already been metabolized and used, from the active ingredient in some of the blood results. Mm-hmm. But those can show up for some time afterwards, and it's sort of proof, if you will, that the person engages. Right. So, but it's again very hard to distinguish and very hard to interpret. Another point, and you didn't ask this, and lawyers, that's what we do, is we answer questions that are never asked. But another kind of a nuanced point here is that alcohol is the only substance that has a per se intoxication limit, 0.08. The studies show that nobody's safe to drive regardless of your tolerance level at 0.08. The same is not true with cannabis or other medications, for the reason that some people are clinical users, some people are recreational users, and people have varying tolerances. Very complicated stuff.
So there is no, shall we say, bar that you have to cross before, you've smoked too much pot, you're driving under the influence, as opposed to, oh yeah, you only had like one puff, and so you're good to go. There's no parts per million, I guess is what I'm trying to say. There's no parts per million delineation as far as how much it is that it makes you considered to be stoned and driving under the influence.
I don't know that any state has passed a per se line in the sand like you're describing when it comes to cannabis or any other product other than alcohol. Maybe that changes at some point. I think everybody would hope that would be data and science driven. But yeah, that's the really tricky part, because again, if you take even opiates, some people are prescribed them, some people use them every day. So they're going to have, obviously, they can have a much higher level in their system and maybe be okay to operate a car. But if you take somebody who's never had that in their entire life and they take a half of a pill, they may ought to be nowhere near any of this equipment. So, and they're, even though their blood test would show they're much, much lower, it's actually affected them in a lot greater capacity. So, yeah, it's you hit the nail on the head with that.
So, as an attorney, and you're a defense attorney, with all the complications then of proving it, trying to prove that they were actually intoxicated, it seems to me that it's would probably be much easier to get somebody off driving under the influence of marijuana than it is trying to get somebody off driving under the influence of booze.
Potentially, it depends on a lot of things. A lot of it's the smell test, right? Pardon the pun, but a lot of it's the smell test. I mean, if somebody looks okay and acts okay, and a police officer saying, "No, I can really tell," or they just look like they're off their rocker, and everybody can tell there's something wrong, and this person did something very dangerous. Most folks tend to get it, but it's very tricky. And not only that, it also depends on where you are and the substances that you're using. People understand in the year 2024, they understand THC, they understand cannabis. But if you have evidence that somebody has got heroin in their system, people don't understand that and people don't like that. So a lot of times those are sort of factors that can kind of play in and maybe persuade a jury. But I mean, you kind of know it when you see it, is sort of the thing of it. And that's what the jury sort of cues in on. So really it's going to show if you're safe to drive, then hopefully it's apparent. And if it's apparent enough, a jury would do the right thing. And if it's not apparent enough, then hopefully the jury would do the right thing and acquit. That's how these go.
Are the typical things that, somebody that's driving, say, under the influence of marijuana, I mean, is it the same kind of things? They're not holding their lane, maybe running a stop sign or a light. I mean, does it vary from driving under the influence of alcohol? I mean, are there things that officers can look for and go, that just doesn't look right?
I'm sure there's a lot of similarities to it. I actually read a study that said that when you're impaired with THC, that you tend to be more conservative, more paranoid. When you're intoxicated with alcohol, maybe less judgment, more aggressive. So, but if you have cannabis, for instance, you might be driving too slow. You may be overly safe, overly cautious, which can be, I'm sure, just as dangerous. But those are also things that officers are sort of cued to look for. I mean, really, in most instances, an officer is going to have to see some type of traffic infraction to pull you over. In most instances, not always, maybe a 911 call. So probably you're going to have some bad driving of some sort. And then once the officer gets to the window, starts questioning, starts observing, then investigations tend to go from there.
I'm assuming it depends on locale, but maybe there is a general answer for this. How difficult is it for an officer to get a warrant to induce somebody to take a blood test?
In Texas, not difficult. In other parts of the country, maybe less, maybe more. But it's really not that hard. These days, police are very good at it. They've got judges that are sort of standing by, and a lot of times they're rubber stamped. It's usually the exception and not the rule. In DWI enforcement and DUI, OUI, whatever you call it, it's usually, most cases we're seeing some type of blood test, maybe a urine test or something like that. But a warrant, typically for blood, very common.
All right. Hey, we appreciate you joining us on the Wake Up Call this morning, Jeremy. Thanks.
Thanks for having me.
All right. You take care. Jeremy Rosenthal, founder of Rosenthal, Cannabis, and Therian Law.